All right, I think we're going to get started in 1 second. Just have to give me a moment to get all the technology up and running for you. Okay, good evening. Welcome to the Micklen Law Group's monthly webinar. Today's webinar is called Your Fair Share, How to Contest a Will in New Jersey. All right, I'm going to jump right into it, give you some information about today's webinar. It is scheduled for 60 minutes. Sometimes it's a little shorter, sometimes it's a little longer. I never know exactly how long it's going to take me to get through the information, but I do try to leave some time at the end for questions. I usually like to leave at least a few minutes. I will stay on as long as necessary afterwards to answer any questions, but I do try to keep it within the time frame for those that signed on and plan to only be here for an hour. The webinar is a one-way communication, so you should be able to see my screen and hear me, but I can't hear you. I did a sound test and it looked fine before. If somebody could just send me a message, let me know that you're able to see the slide that says today's webinar. All right, looks like we're good to go. Okay, so like I said, I will be staying for questions afterwards. There is a chat panel you should have on the right side. Well, it depends where you put it. Usually it comes on the right side of your screen. And there's a question box. I usually recommend people put in their questions throughout the webinar so that you don't forget it when we move on to other topics, but I won't answer them until the end of the webinar. Like I said, I'm going to do what I can to answer everything, no matter how long it takes us. Moving right along, this is me. My name is Brad Micklen. For those that haven't worked with me, I'm the managing member of the Micklen Law Group. I'm a member of the New Jersey and Pennsylvania state bars. I'm also licensed in both the state and federal courts. I began my legal career working as a judicial law clerk for Judge Austin in this special civil part. From there, I went on to Kessler & Associates in Clifton, New Jersey. I did complex commercial litigation for a number of years. Found that while I liked the complexity of the litigation, I didn't care much for representing businesses. I like dealing more with people. So I left that office and opened my own practice about 15 years ago now. Our practice is concentrated in divorce, family law, and estate planning issues. I handle most of the high conflict, high net worth litigation, both in divorce and estate planning and contest, which is what we're going to be talking about mostly today. This slide is just some awards I've received recently. More on the left side are the more recent ones from the American Academy of Trial Attorneys, Nation's Top 1%, American Institute of Family Law Attorneys. I put these up here not as a way to boast myself, but so that you have a sense that I do know what I'm talking about. I've often said to clients, you don't know if you have a good lawyer until it's over, which is unfortunate for many people. So I like people to have as much information about me as possible, even just so that you know you can take good credibility in what we're discussing today. So let me cover what we will be discussing. This is just a general overview. First, we're going to be talking about prosecuting claims, defending claims, and then other issues that are related to them. So when it comes to prosecuting claims, we're going to talk about the time frame to file. You'll see there's a difference whether you're in state or out of state, whether it's a New Jersey state that you're contesting, or if you live out of state, contesting in New Jersey case, your time is different. We're going to talk about the documents that you'll need. That will differ depending on which type of action you're engaged in, which we'll talk about the types of actions later. I'll talk about documents that you need to file and when you have to file them, because again, everything's different depending on the type of action. We'll discuss the relief you want to seek or what you're going to ask the court to give you. You need to put some real thought into that, and I'll explain later why, because again, you need to really be able to think through to the end of the case to make sure that you're going to get what you need. We'll discuss the standard of proof for each different type of challenge or prosecution that you may have. They will differ for some of them. It's not always going to be the same. And lastly, we'll talk about the proofs, the legal proofs that you need in able to successfully prosecute a will contest. Then conversely, we're going to talk about what it takes to defend a claim. We'll discuss what the burden of proof is. It's in many ways similar, but it's going to have a different kind of twist to it, and you'll have to definitely take a different approach. We'll talk about what filing a counterclaim is for those that have been involved in litigation in the past. It's very different in the court, which is called the probate court, or the probate part that handles these types of litigations. Filing a counterclaim is different in this type of litigation than it is in most others. We'll talk about discovery, which is the exchange of information. Often it's going to be similar to the discovery for prosecuting a claim also, but different information that you want to seek. You want to be prepared for at least what types of information and how you can ask for it. Lastly, we'll talk about experts, what type of experts you need, maybe some of the benefits and detriments to having them, and how to best prepare to get some. And then lastly, we're going to talk about other issues. We're going to talk about the nature of the personal relationships that are often involved in probate matters and will contests. We'll talk about the fees, legal fees, expert fees, and other related costs that are associated with the litigation. And lastly, we're going to touch on some conflicts, just usually involved with lawyers that may have been involved either in the beginning of the document preparation, or even if they're later involved in the actual contest that you may be involved in. So let's break it down first a little bit here. Prosecution, we're going to talk about again just real quick if you want to just take some notes down. We're going to talk about the time frame to file, your documents that you're going to need, documents that you're going to file with the court, and the difference being the documents you need to support your case are different from the documents that will be drafted and filed with the court. The relief to seek, standard of proof, and the actual proofs that you need. Before we move on, there's a couple things I want to give to you, just some terms that are going to come up throughout this to make sure we're clear. First, when I say probate court, that is the division of the court that handles wills and trust matters. The two main divisions in New Jersey of the court are the civil court and the chancery court. Civil court deals with money damages. Chancery court deals with everything that isn't money damages. So in the chancery division, we have different parts. You have family part, you have probate part. The probate part is where you file these kinds of actions. The word probate itself is the legal term for administrating an estate or handling an estate. Once you file a will or you file to handle somebody's estate, it will go through what is called probate. So we'll be using that term. And then we'll also talk about letters testamentary, which is what the court gives to you when you file for probate. And it's usually those are the letters that you use to then get assets and to administer the estate. So these terms may come up throughout the discussion. We'll make sure that we're clear on that. So let's move right into the time frame to file, our first topic. So there's going to be 2 or 3 different ways that you have to look at when and how to file. And it's going to depend partly on what the law says, but also partly on when you discover that you have a claim and where you live. So the first is it should be prior to the probating of a will. In New Jersey, you file what's called a caveat. A will, when somebody passes, whether they pass with a will or without a will, nobody is allowed to go to the probate court to start the probate process for 10 days after the passing. The intention of this 10-day waiting period is in case there is anybody who wants to file what's called a caveat or an objection to the will or estate being probated, they can do so inside of those 10 days. If you file a caveat in those 10 days, the court will then not allow the will itself to be probated, will not enter in the probate process, and instead will go through the litigation of the contest or challenge itself. Now, if you're in New Jersey, you can file after these 10 days, but up to 4 months after when it says the will is probated or letters of appointment are granted. That's what I was talking about before. It's when the will is offered, it's considered probated, not even though it's not completed. You have up to 4 months. Now you'll file that differently than you'll file a caveat. Caveat's a much smaller, simpler document, which often you can find online. If you're filing after the 10 days, but within the 4 months, you're going to file an order to show cause and other supporting documents, which we will touch on later. Just give me 1 second. I need to check something real quick. Okay. Now, if you live outside of New Jersey, that time period is extended for 2 more months. So you have up to 6 months before you're barred from filing, before 6 months before the letters of appointment are granted or probate is entered. And the reason is usually people that are living outside find out much later than people living in state. Now, most of the time, you might be wondering, how do you find out? Generally, a person who offers a will to probate or an estate into a probate part for administration is required to put anybody that is reasonably likely to take under the estate on notice. So you'll get either a notice of probate and or a copy of the will that's being attached or that's being probated if it's probated with a will. And the receipt of that document will let you know whether or not there is a potential challenge that you'd want to look into. And we'll discuss later in this webinar, what those issues are. Now, there's also some case law that says that you can file within a reasonable time under the circumstances if released, if based on fraud. The thing about that, there's many different ways to approach this. First of all, I think the rules allow to file a motion to extend the filing date by 30 days, almost as a matter of right. So what you'd be doing there is, let's say you find out that your 4 or 6 month time's about to lapse, and you can't really get a challenge in sufficiently in the limited time that you have. You can file a motion. The motion to extend would be a lot easier to get done, whether it's by yourself or with an attorney, in a short period of time than drafting the full contest. You might also need to get certain documents and things, again, that we'll discuss later. So filing the motion to extend will sort of buy you more time if you're running short on the 4 or 6 month window. There's also some support in the court rules, even if you passed this point, the 6 months, and I've done it on occasions. The court that we're in, the Chancery Court, as I said, it deals with what's not money issues. And technically, the Chancery Division is a court of what's considered fairness, or a court of equity. So there's often ways to relax many of the guidelines. For instance, one of the New Jersey court rules, it's 4:50, is a rule that allows to vacate a judgment within a year's time. And there's several different reasons: fraud, extenuating circumstances, satisfaction. So the rule sets forth a lot of reasons why a person can seek to vacate a judgment. It also has a catch-all provision that says any other circumstances that would warrant a vacating of the judgment. So you can use 450 and the equity rules to go in much later, because the court's more concerned with hearing the issue and making sure that it's resolved correctly than standing to rigid timeframes. And also, because the probate process itself is a very long process, there's often not much that's being interfered or prohibited during that time. An average probate of an average estate, even a minor complexity estate, will take a year or two. So 4 months into it, or even 6 months into it, there's still a lot that needs to be done, and that the courts often feel that interrupting the process to hear the contest is more fair than denying it because a time frame may have lapsed. It's better to get sort of to the bottom of it. I think is how the courts often look at it. So let's look at the documents that you may need. There's going to be statements. If you have statements made by the testator, lay and expert testimony, medical records, writings, and prior wills. Now, each of these may or may not be available to you, and you need to know what's going to be helpful and get as much as possible. So when you're looking at statements made by the testator, first thing you want to look to try to find are statements made prior to, during, or shortly after the execution or the signing of whatever document you're challenging. And we'll talk more about this at length, but the reason is the issue will become a capacity issue, and the closer to the date of signing, the easier it is to argue whether there was or was not lack of capacity. Somebody could be fine on Wednesday and not on Thursday. So you want to have as many statements around the time of execution as possible. Now, a lot of times you'll have direct testimony of people that are going to be witnesses. This is more for will contest due to the execution or capacity. Not often as common for claims of undue influence, which we'll talk about a little more thoroughly later. Lay and expert testimony. Lay testimony is just basically a person who's not a professional or not being called for a professional related reason. It could be family members, could be friends, Often it's neighbors or people in the neighborhood that might be familiar with the circumstances. My opinion, sort of with lay testimony, especially in preparation and your first initial filing, is that the more you have, the better it is. You want to get as much as you can before you file, even if you're not using it for your initial filing, because you're going to need it later to support the case. So you want to have as much as possible going into the case so that you're ready when there are challenges to it later. Expert testimony, again, anybody who's an expert, it could be a medical testimony, it may be legal experts, it could be handwriting experts are often very common. Many other types are forensic accountants, financial experts, but the main ones, most often you're dealing with medical, which is why we say medical records are important. Sometimes you run into a problem with medical records because of the HIPAA laws and you can't necessarily get to them. The person that's handling the estate that you're challenging, usually it's either called an executor or an administrator, which we'll talk about later, they can get medical records because they are considered in the law as if they are the person who passed. They sort of stand in the shoes of the decedent. So you might need to work with them. So it's not likely you'll have medical records before you start the case, but you will receive it through discovery, which we'll also talk about in a couple minutes. Writings, you want to have copies of prior writings. It can be anything. It can be prior documents like wills, inconsistent wills and trusts that were drafts or notes, letters, although not many people write letters nowadays, but I think the older generation may still do that to their lawyers, to their friends. Emails, obviously very common. Attorney correspondence, again, you're running into a confidentiality issue, but in many cases, the attorneys that draft the document are going to be witnesses. You should be able to receive copies of their documents. And then when you're talking about prior wills, the reason that you want to get that is you want to look for many different things. First of all, you want to look, depending on the nature of your challenge, whether it's a challenge to the capacity or competency of the person or a challenge to the document itself, you want to look at prior wills, make sure that they were executed with formalities. You also want to know if they were better or worse for your case, because if you're challenging one document and it's revoked, if there's a chance that you're going to reinstate something that's less favorable, you want to know that before you walk in on an execution. And lastly, you also want to look at the signatures, because more often than not, a challenge has a lot to do with one's capacity, regardless of the reason, whether it's a capacity directly issue, an undue influence, or even a formality. But the person's capacity to understand everything that was going on is always going to be an underlying issue. And you can often tell a lot by their signatures and how their signatures change, which is why you often have an expert as a handwriting expert. But even a layperson can look and tell when somebody's sort of decrepit or maybe decaying in their health just by looking at their signature. It's almost like a common sense approach, initially at least. So let's look, once you have these documents, what are you going to need to file? And in a nutshell, here's the court rule that will spell it out for you. You're going to file an order show cause, a verified complaint, letter brief, proposed judgment, a fee certification, that's an attorney fee certification if you have a lawyer, and a proof of mailing. Now, each document, and if you're representing yourself, it's going to be slightly different, I think, than if you have a lawyer. My comments are going to be as if you were doing this yourself, because many people at least begin the challenges on their own or they file the caveats on their own. An order show cause is the document which sets forth, and there's a specific order and form that you need to have, so you can either get it online or from the court. It will specify what you're specifically requesting. Now, in the order show cause that you're filing, you're going to be requesting things temporarily and permanently, even though the court's not necessarily going to be ruling on the permanent relief. You want both of them to be in the order, and you want your order to say that you're asking for certain relief temporarily, A, B, C, and D. And at the final hearing, you're going to be asking for final relief, A, B, C, and D. We'll go through a little bit of what that relief should be at a different section. But you want both of those in. You'll be talking about things like removing executors, or you want an accounting, or undue transfers of property. Whatever you may think that you need, you want to put it into both the initial and the final form of order show cause, but it will be one document that's provided that way. The verified complaint, it's a specific form that will have to set forth certain facts about the case, the individuals involved, both the decedent and family members, addresses, dates that are relevant, and your sort of factual background to what the challenge is. I've seen a lot of people who submit also a client certification with this, and I do it myself, which is sort of just reiterating what's in the verified complaint, but a little more naturally, informally. It's more natural language. I don't think the court rules require it, but I do it. I just think it's a good touch to have it in the client's own words going in. Then there's a letter brief. Now, the court rules do require a letter brief. If you're going to be on your own, it's going to be kind of hard to get a letter brief together. I mean, maybe you can find a lawyer to help you, but the law is pretty clear at the initial filing of what you need to show. So you can pretty much do something, simply get some law off the internet as best as you possibly can, and it would likely be accepted. At the initial filing, they're not going to really be diving into your legal brief. It's more of a fact analysis at that point. The proposed judgment will be what you want at the final hearing. Like I said, you want to itemize that in your order show cause, but in the proposed judgment, now you will also probably get a court's direction at some future hearing of what should be in the proposed judgment. You may even get it after the first appearance. But I usually submit one with my order show cause, and that way I can just amend it based on what the judge wants. Fee certification now. Again, this is for an attorney. Most attorneys should know this. There are court rules that specify how and what you need to ask for. If you are going to attach your invoices, I always remind people to redact, client confidential information, client, specific account information, social security numbers, anything that could be client's protected property. And lastly is a proof of mailing. Now, when you file the order show cause, I normally send a copy to my adversary or the opposing parties. The rules don't actually require it. You can file the order show cause without sending a copy to your other side, which is unusual. Most areas of law don't allow for that, but this does. And then I still submit a proof of mailing when I file because I put in notice that I sent a copy. The courts would usually require you to update your proof of mailing and bring it to the initial hearing that the court sets to show that you served everybody properly. They may even tell you who you need to serve, and if you didn't serve the right people, the people who work in the court, the probate court, called the surrogate, and it's not that they work in there, but that's the simplest way for me to describe it today, is they will usually advise you if you need to tell other people that you did properly. All right, moving right along, what kind of relief do you want to seek if you're challenging this? And this is just an idea. I mean, obviously every case is going to be a little different, but the first one, you might be seeking to set aside a will or a certain provision of the will. You might be asking to probate a different will or to have the wills fail altogether and go by intestate. Now, when you're setting aside a will, you want to look at what I said before, like seeing whether or not the past will was more or less favorable, but also if you're going to be probating a will or the intestate, you want to see what the outcome of those will be. And intestate, by the way, is the law that says if you die without a will, it sets forth how your property is divided or who receives your property. So you really need to sit and look at what you're asking for to make sure that the end result is actually going to be favorable to you. Because just because you might set aside a will, if it goes by intestate and you don't receive under the intestate statute, you're wasting your time. Then there's to either remove or replace the executor or the administrator. Now, the executor and administrator, they're the same person, but the roles are different based on the type of estate. So if you have a will, then you have an executor who's handling your will, or an executrix, if it's a woman that's handling the will. If there's no will and it's going by the intestate statute, you have an administrator or an administratrix. So they're the same person, it's just whether or not there is or isn't a will. So you might be looking to remove that person, you might be looking to replace them. These are things you also need to consider because these individuals do get a certain percentage of the estate. If they're replaced by somebody else, that other person will get those fees. Sometimes you don't want to remove an executor who's far into it because they may have earned the right to get some fees and then you're going to pay a second person to do it. So this is something that you want to consider. Counsel fees and costs. Counsel fees and costs, I always tell my clients, expect not to get your fees back because it's the best way to proceed. That way you're just ahead of the game if you do. But what the law says about fees is in order to have the estate pay your fees, meaning coming sort of off the top out of everybody's share to reimburse your attorney, you have to be filed. It has to be a good faith challenge and it needed to assist in the administration of the estate, meaning it had to serve the estate itself. It had to help everybody sort of resolve the issue. Most of the time, when you're filing a contest, you're really looking to serve one person. But It's not always the case, so you may get fees, but like I said, I don't ever let my clients expect it. You may be seeking an informal or formal accounting. A formal accounting is used by a professional, an accountant that's hired or an expert hired, and reviews all the transactions. So one county, I can't remember offhand, actually does a formal accounting in the courthouse. They do it for you. I'm not sure if there was a cost associated or not. And then there's an informal accounting. More often you'll do that because it's faster and much less expensive. Same kind of information that an accountant would gather, and just the expenses and income of an estate to make sure that everything is handled properly and that nothing is missing. And lastly, you may or may not be seeking a court-appointed receiver or administrator. A court-appointed receiver is usually somebody who's coming in to run a piece of property or a valuable asset. That's very costly and can be very taxing on a estate, so it's not granted often because it can be very challenging to an estate to handle that kind of a cost. And then removing the court-appointed administrator goes back to the removing or replacing executor. Sometimes the court will name somebody if you don't have a party that's capable or qualified to do so. Standard of proof. Now, there's three main challenges that we're talking about when you talk about a will contest. One is you're claiming the testator was incompetent when they signed the will. Second is that the testator was under undue influence. And the last is that the document itself, the will or a trust, lacks formalities. It wasn't completed in conformity with the law. So the first two, the standard of proof that you need to show to be successful is clear and convincing evidence. That's defined as more highly probable to be true than not. Another case is defined that as a judge has to have a firm belief or conviction that it is true. That is a little lower of a standard than that which is required for a deficient will or lacks formality. The preponderance of the evidence is the greater weight of evidence is more convincing. It's been sort of said in simpler terms like more than 50%, a little more than 50%. I think the standard for the deficient will is a little higher than the clear and convincing. Well, it is higher than the clear and convincing. I think the reason for that is because the issues are a lot more clear. You can tell if a will is or is not executed in conformity with the statute. So you don't want everybody running in because it seems to be incorrect. You want it to be a higher burden so that there's fewer reasons to do it. The ultimate problem with both of these standards is, while they sound very nice and there's nice definitions to it, there's really nothing that tells you exactly what that means. Every case is going to be different. Every judge's opinion of what is clear and convincing is going to be different. So you can't really find before you go in whether you have enough to satisfy clear and convincing, or if you have more than 50% to be preponderance of the evidence. You really just have to hope that your case is convincing. So what proofs are you going to be looking to provide? Again, we're talking about incompetent testator, undue influence, and deficient wills. So for an incompetent testator, a person is presumed to be of sound mind and competent when they have had executed a will, meaning somebody signs a will and dies, nobody's looking at it until the person's passed. But they're going to presume that when that person signed the will, his or her will, he or she was of sound mind and competent. So the person who's contesting the will must prove that the person was incompetent. And what's important is you have to prove it at the time of signing, which is very difficult, again, going back to what I referenced earlier, because people have different levels of capacity and competency. For instance, somebody that has Alzheimer's doesn't necessarily mean they are unable to remember things every single day. It sort of comes and goes. So one day they're good, one day they're not. You need to find out what happened on that very day, and that's a very challenging thing to determine. Next is the more common challenges I see: undue influence. This is presumed where the will benefits a person who had, 1, a confidential relationship with the testator, and 2, has suspicious circumstances. And I highlighted those beneath the sentence because they're very important, because, again, this is a very important, a very prevalent area. Undue influence itself is defined as a person who has been unable to exert his or her own wishes due to somebody else's control. Because the important thing to remember is not all influence is undue. There are many people who are influenced by family members. A typical situation is a child moves in to take care of their parent and convinces the parent to change their will because they've been taking care of the parent all these years. that's influence doesn't necessarily mean it's undue influence, and that's where the shade of gray comes up. So the confidential relationship, which is what I was saying, their sister or daughter moved in, and a suspicious circumstance. I call it an unnatural disposition, so I look for a confidential relationship and an unnatural disposition. The confidential relationship, again, is usually somebody who lives close by or had a very close relationship, had access to the testator where people wouldn't necessarily see what was happening between the two of them. And the suspicious circumstances or unnatural disposition is really going to be fact specific to the case, but most commonly it's things like when one sibling is omitted, especially if it's shortly before the person's death, or if there was a spouse or an ex-spouse that maybe received but a current spouse did not, or a caregiver, a very common situation. A caregiver is all of a sudden the largest recipient under a will where a person has more natural heirs like children or spouses or close relatives. And then last is the deficient will doesn't comply with statutory requirements. Wills have to have certain things in order to be valid. One, the person who executes the will must be 18 years or older in order to just basically be able to contract. Has to have 2 witnesses that sign it, has to be notarized. Now, there is something called a holographic will, and I think it's now called something different, but for the first 100 years of this, it was holographic, where somebody tries to handwrite their will, which is also very common. People often on their deathbed are trying to write something out to help their beneficiaries. A piece of paper with a writing will be considered a will if it's signed by the testator and the material portions of the will are in that person's writing. That's very tricky, something I'm not going to get into at great length. It's really specific to that kind of an action if you're bringing it. My observation is over the last few years, and I think going forward, courts are starting to relax the rigidity of what they used to require for wills to be in compliance. It used to be if the will wasn't in exact compliance, 18, 2 witnesses, notary, it was tossed out. Or if there was something crossed on it, it was tossed out. Now they're starting to look more to the circumstances. Did the person intend necessarily to revoke the will, or did they intend for it to stay in it? They're sort of loosening up, and I think because of the changes of technology and the ease with which people create these documents, it's causing the courts to look a little less rigid at whether or not it's considered deficient or not. So let's look at the other side of the coin for a minute. And if you're defending one of these claims, let's say you are either the executor or you're the recipient under the will that's receiving what's considered an unnatural disposition. So let's talk a little bit about the burden of proof that you will need to show, whether you have a counterclaim or a lawsuit against the people that are suing you or the estate, discovery, and experts. So turning first to burden of proof. The first one is, again, you're challenging if there is a showing that the testator was incompetent. And remember, like I said, it's a very low threshold because the person is presumed to be competent. All you need to show is that the person comprehended his or her property, understood the meaning of the business he or she was engaged in, meaning that they were drafting this document, the relationship of each factor of their either the property or their disposition, and they understood the distribution of the assets that they were disposing of. Like I said, not all issues of competence or even undue influence are sufficient. So even if there's a showing, you still have the right to rebut it. So turning to the undue influence issues. Again, confidential relationship, unnatural disposition. The courts will look at if there was sort of a trust developed by the testator and whether that person suffered from any kind of weakness or dependency or reliance on the influencer was shown. So your defending burden of proof would be to show that the testator was weak or dependent. More often than not, these are elderly people. It's caregivers, whether it's family or hired help, that are the subjects of undue influence. So you would be developing testimony to show that the testator was relying upon them in a very strong way. What you want to be able to show, how the case is defined, is that the testator's mental, moral, or physical exertion, I'm sorry, not the testators, but the caregiver's mental, moral, or physical exertion that destroys the testator's free agency. that he or she is unable to exercise their own judgment. That's what your burden of proof is for undue influence once they've shown the confidential relationship and unnatural disposition. And then additionally, with undue influence, you can rebut the presumption when there is a professional conflict of interest on the part of the attorney. Like, for instance, an attorney is not supposed to be receiving a substantial gift. So if there is a challenge to a document and the attorney who drafted it receives a substantial gift, that may be an additional conflict that may lend to the other issues that you're sort of challenging. And again, lastly, I know I keep saying this over and over again, confidential relationship between the testator and the beneficiary as well as the attorney. This depends on the relationship and the people in interaction. So it's going to be a very fact-specific question. In my opinion, the undue influence challenge is harder to defend because once you have the two prongs, confidential relationship, unnatural disposition, it shifts to you to prove something else. And that's often very difficult because, again, a lot of these situations do have these two, but it's just not undue. It's sort of that shade of gray of providing the level or defending against level, whichever we stand on. That makes it very, very challenging. It makes it probably the most common type of litigation that you see right now. So let's say if you have additional claims that you want to file. It's called a counterclaim. Now, in most lawsuits, when somebody files a claim against you, you just file a counterclaim. You file an answer and a counterclaim. It's just part and parcel to doing that. In the probate court, it's different. Now, it's still similar in what it's seeking. It's you seeking affirmative relief from the action in hand. But in the probate court, you actually have to seek permission by the court. You have to file papers and ask to file this action. And essentially, simply, is because probate court is a court of limited jurisdiction. So that means that they don't hear every type of action about every type of matter. So they would need to know that the claim that you have, your counterclaim, is something that the court can hear. Most often, you're going to be seeking to either deny the request or deny the challenge and seeking counsel fees or costs to be paid. Those are the most common forms of a counterclaim. And you do that to sort of level the playing field in case you are going to get engaged in litigation and costs. But there's another issue to consider, and this goes to where the court's limited in its jurisdiction. New Jersey law has a doctrine called entire controversy, which basically says if you have a lawsuit against somebody, you must bring all claims you have against that person in one lawsuit or you're barred from doing it again. The intention is they don't want 5 different lawsuits and inconsistent judgments and taking up all the court's time for it, so they say bring them in one case at one time. The problem is the probate court doesn't have the power to hear all types of matters. You can't bring a breach of contract for your lease agreement in probate court. But if it happens to be your landlord that is challenging the will of your uncle and you having a claim against him for habitability issues, whatever it may be, just grabbing something, you may need to consult with whether or not you can bring that in or whether or not it can properly be held separately. Now, the example I mentioned probably would be heard separately, but just trying to make the point. It's something you need to watch and be careful about. So once you are engaged and your claim and your counterclaim have been filed, or the complaint and your counterclaim have been filed, you're then going to engage in what's called discovery. And discovery is essentially just the exchange of information. There will be a specified amount of time that you can request and be required to exchange discovery. The types of discovery you're going to possibly have: interrogatories, which are written questions that are answered under oath; document productions, which are called notice to produce documents, and that will be requesting, obviously, documents, certain types of documents. You have expert reports, both sides, and you may have depositions of witnesses and interested parties. Another thing that's not in here, because I haven't seen it too often, is requests for admissions, but they can be very effective considering the specific burdens of proof that you have on each side of these cases. Requests for admissions are written statements, sort of in a yes or no question, and the person has to either say yes or no or explain why they can't answer it. And it's a very good way to elicit crucial testimony in a simple way. Interrogatories are good, but they're very cumbersome. Depositions are very good also. Depositions are question and answers under oath. They're very lengthy and expensive. Requests for admissions in many cases will give you answers to very important issues in a very quick and simple way. So I like them. I just don't see many people using them. Now, discovery in probate actions is often handled a little different than it is in most. So if you've been in like civil litigation or matrimonial litigation, discovery, the court will set up a period of time to exchange discovery, and then you come back and the court says, okay, have you gotten all the discovery? Now we go to trial. In the probate part, the judges more often than not limit the amount of discovery on an issue or to a period of time, and then once that one issue or that limitation has been resolved, then you come back and they say, okay, now you can look, if you need to, at these other issues. Essentially, what I think they're trying to do is limit the litigation, since the issues are very narrow. They'll, for instance, have discovery on the testator's competency and not the financial damages, because if you can't prove competency, damages aren't relevant. So they don't want you to exchange all this information for issues that you may not get to. They tailor it so that you're addressing what's important at the time, and then you move through litigation or through stages. It's good in that it reduces litigation. It's bad in that it prolongs litigation, which then raises costs. So it's kind of a balancing that the courts do. Experts may be retained. If they are retained, they must supply a report. They may be deposed by both parties. Many cases, or many instances, the court will actually appoint an expert to resolve an issue initially upon a party's filing of an action, which I always think is better. I usually file an action asking for a court-appointed expert, because the rules say if you get a court-appointed expert, you still reserve the right to get your own. And the reason we want to do that is if the expert that's court-appointed is favorable to you, then that's good for your case, because you don't need to go and expend the money for your own expert report. And the fees may likely be paid out of the estate, so that you're saving that litigation and getting a favorable response. If you go and get your own expert, a lot of times you get a bad report. Now you're married to that report, and you have no credible way of getting another one. The adverse party must be provided with your expert report. I also ask for the notes that went into my expert report. So that's part of discovery, going back to what we just talked about. When you get a report from your expert, ask for their notes so you can see what was discussed. You can see if there's something that was inconsistent or omitted. You can also see if there's something that's erroneous. Maybe they mistyped something or they changed their view. Very telling what they put in their notes and what they put in their reports. Always get that. And last, and this is just kind of an obvious caveat, they're expensive. You really want to think this through. And I put that there because part of my theme when it comes to all will contests of any nature is you really need to be looking at the end of your case to make sure that what you're doing is in your best interest. It's very difficult. It's very costly. And if you're fighting for something that either you're not entitled to, or if you win that you really don't win, you want to know that going into it before you actually engage in such protracted long litigation. Look at some other issues. We're going to be wrapping this up in a second. I say these other issues are really significant in my opinion. And I sit with my clients and go through this thoroughly, because first is the personal relationships. The people that are involved, the players, let's say, the executors and the administrators and the beneficiaries, they're going through a tough time. Whether you think they're good or bad people, or they did something good or bad to somebody, they probably lost somebody that they care a great deal about. And that's going to affect how they handle themselves. It's going to affect how they handle their litigation. You want to be sensitive to that, because as a person challenging it, you may or may not have suffered the same loss, but you should at least understand that they're suffering the loss that you feel you suffered. Will contests can stress or destroy relationships. Whenever I have somebody who comes in with an undue influence claim, it's usually one sibling over another, I ask them how important it is maintaining this relationship, because it's very possible that you'll destroy it in this litigation. And if it's an important relationship, you want to know that, because then you handle your case differently. And the last to remember is people have the right to distribute the property as they see fit. Again, something I repeat throughout this, not all influence is undue influence. It's not necessarily strange that a person who is giving somebody care for the last years of their life might get more of their estate. I personally would probably do that, except for knowing what I do know about this. But if I had several children and one of them was a significant caregiver to me, I might give them an unnatural greater share of the will. I think you need to keep that in mind. If you had such a close relationship with the person who passed, determine whether or not you think that, even though it might be unnatural, if it makes sense for that person. Another thing to consider, very important, is fees. If probate is refused, if it's granted, or even in administration. If it's refused, that's if you file a caveat or an order to show cause. Probate's refused, you're going to possibly incur significant legal fees in the prosecution of your claim or in the defending of your claim. And that can be anywhere in average from 1 to 3 years, I've seen in most probate litigations. And that's not of any great significant complex issues. It's at least going to be 1 to 3 years. There's going to be additional fees if probate is granted, meaning if you file a caveat or an order to show cause and it denies the will for going into probate, and then you have a 1 to 3 year litigation over the issue, the estate still must be probated afterwards. So you may still have another year of actual probate, and the person who's going to probate is going to get his or her commissions for probating it. So now what was 3 years is now 4 years, and a significant amount of fees. Many people seem to forget. They get so embroiled in the will contest that once they're done, they're still not done, and they still may have to wait another year. So now tensions are high, costs are up, and you've really just begun the process. And last, I mentioned this earlier about assisting administration. Your fees are likely to be reimbursed to some extent only if your action did assist in the administration of the estate, and more often than not, it won't be considered that. It will be considered to benefit just your client or yourself, depending on where you stand in this. Last, just a quick issue about conflicts. The attorney who drafted the will is usually going to be a witness, and that person can't or shouldn't be a representative of one of the parties. I put this in here because it's common that a lot of lawyers don't seem to recognize this conflict. Somebody will be like, say, the family lawyer, and they draft a will for this person, and then the will is contested later, and the heirs or the beneficiaries hire the same lawyer because it's the family lawyer and they know them. But the rules of professional conduct indicate if you're likely to be a material witness, you can't be an advocate for a person in that same action. And I see this often come up because they don't consider it to be that significant. I think it is. I think it's something that lawyers need to look at. If you're going to hire a lawyer, you want to make sure that they were not involved, not only with the drafting of the documents, but not with any of the parties to the will contest either. That is all that I have on this topic. Like I said, I will take any questions. Let me just get a second to open up. All right, so now my screen's a little different than yours. So if you posted questions beforehand, it's a lot easier to write them afterwards. I see there might be 1 or 2 that were posted before, but if you still have the question, if I didn't address it, just type it below or type it again. Okay, I'm not seeing any questions. I'm going to give it another minute or 2 to hang out just to make sure that everybody can hear me. And I have one question here. It says, how do we deal with an executrix who refuses to complete distribution from the sale of a shared estate asset? It's going to depend a little bit on where the probate process is and the type of asset. The executrix in most cases has great authority to determine what and when to distribute assets, whether or not to liquidate assets or keep them in the same form and just distribute them in what's called in kind. Also, just because they've liquidated assets to the estate, they can't do distributions until the probate process is complete because there are many things that need to be done. Certain bills and expenses need to be paid. Taxes need to be paid, not paid, paid if there are taxes. Estate taxes and inheritance taxes need to be addressed, or at least estate taxes need to be addressed. Tax returns must be filed. The individual's last year tax returns and the estate tax returns, and the recipients or the intended recipients also need to sign what's called a refunding bond, which is a promise to pay back the money they receive in the event it's found that there's a bill or an expense that wasn't paid for. So if all of that's being done, then the executrix should distribute the money. I think the key is to find out why the executrix has not. How long have you been in probate before making any decisions? Now, the answer to your question is if you find out that he or she, or executrix, so it's a she, has done something wrong or is just trying to frustrate the probate process, you can file an order show cause, like I discussed in the beginning, to have her removed, and you or somebody else appointed the executrix in her place. In many cases, in most cases, courts, I've seen them not actually do that because the judges feel that removing a person who's been so deeply involved is going to increase costs and difficulty and complexity to the estate to have somebody new come in and reinvent the wheel. So you may want to file in addition to that, because you still want to ask for it, even though it's rarely granted, you still want to ask for it. In addition to that, I think you want to ask for an immediate distribution or a partial distribution. If you have a sizable estate and you can tell that there's certainly going to be excess for distribution, there's nothing wrong with signing a partial refunding bond for an amount and having distributions done all the time. Okay, so you're saying it's been 4 years since the sale of the house. Yeah, that 4 years is very strange. It's not to say it's impossible, but 4 years, if the house is sold, it means that probate would have started before then. Now you also have to look at if there's loss of the use of the money, if there is loss of income. You may have a damage issue against the executrix for failing to preserve the assets properly, or being a prudent investor with the proceeds. I don't know what they did with it, but it sounds to me like there's something wrong there. If it's been 4 years, and you might want to look at taking some legal action. Any other questions? Like I said, I'll take as much time as necessary. I don't see any coming up. All right, if I happen to cut you short, or if I missed a question, feel free to email me. I think my email is listed up there for you. It's brad@micklinlawgroup.com. There's info@micklinlawgroup.com, but you can email me directly and just be brad@micklinlawgroup.com. It's a lot better that way. That being said, I thank you for attending, and hopefully you can come to our other webinars each month. We usually do them the last Thursday of each month. We did this one earlier because I didn't think you'd want to be coming out on Thanksgiving to listen to me. So I hope this helped you. If you have anything more that you need, please let me know. And other than that, have a good night.